All right, welcome to the Labor, Health, and Social Services Committee today. And we have a few members out presenting bills in other committees. So just a few ground rules as we get started. Remember to always go through the chairman, state your name, try not to be derogatory to anyone else's opinion. And we want to focus on the merits of the bill. We will allow the presenter and her expert witnesses, if you'd like to come up, and she will present the bill, and then we will have a 2-minute time limit on public comments. So with that, Clayton, would you please call the roll?
Senator Crum,
Excused.
Senator Hutchings,
Here.
Senator Scott,
Here.
Senator Steinmetz,
Here.
Chairman Brennan.
Excused, and she will be joining us later. Well, welcome, Representative Lawley. We will be hearing your House Bill 117, Stop Harm, Empower Women with Informed Notices. Welcome to our committee, and please go ahead and also feel free to call on your expert witnesses in the order you would like. I believe those online have been admitted into our Zoom, and so you should be good to go. And
Thank you so much, Madam Chairwoman. I really appreciate Labor and Health, the opportunity to be with you on the Senate side. I don't see much of you, but I'm good to see you this afternoon and appreciate the opportunity to present House Bill 117. As the good chairman mentioned, it is called Stop Harm, Empower Women with Informed Choices. And what I'd like to do is give a brief description of the bill, to have an understanding of what it does or what it doesn't do, and then go through the bill with the committee, if that's fine.
that's great. Go
Thank
right
you.
ahead.
Thank you. House Bill 117 empowers a woman, not the state, to enforce her own right to be fully informed and free from coercion in deciding about a possible abortion. And I'd like to repeat that. It's really important to understand that this bill empowers a woman, not the state, to enforce her own right to be fully informed and to be free from coercion. That's what the bill does. The bill does not mandate the state to take any action. Rather, it provides a private right of action for a woman who is harmed by the performance of an elective abortion against any person who performs the abortion in situations where the harm was due to negligent, reckless, or intentional conduct, voluntary informed written consent was not given, or the abortion provider knew or should have known that the interested party was coerced into the abortion. This bill does not apply to emergencies. It is well settled in law that adequate and legitimate informed consent is necessary for a woman considering an abortion. She cannot agree to medical intervention unless she is competent, adequately informed, and not coerced into giving her consent. The bill defines adequate and informed consent and coercion for purposes of this private cause of action. As you will see in the findings and hear in testimony today, many women are coerced into having abortions. This alarming and dangerous reality is something we don't talk enough about. In many cases, women are not receiving adequate information before being asked to give their consent. Women deserve the right to seek and recover damages from the person who performed an elective abortion in these circumstances that resulted in harm to the woman. That is what the bill will do. It is a tool for women to protect themselves. And I'll walk through the bill, and then I will call on some of the experts that will support some of the findings in the bill. So on the bill, and we're looking at the engrossed version, hopefully we'll all have that. And so as we work through the bill, we start with some legislative findings. There's about 2 pages and 7 different findings of the legislature. Some of these findings are sort of self-proving. They're quotes from Supreme Court cases about informed consent. Others have studies behind them, peer-reviewed studies, and then some are just some basic facts that are kind of are uncontested, if you will. But we will have some testimony that will relate to these findings as well. And so you see those 7 findings. And then we get over to page 4. And let me point out one thing is that I think it's helpful on page 4, lines 1 through 11. that paragraph, it tells the purpose of the bill in pretty clear language. And I think that's helpful, not only for the committee, but for the public, what the bill does and doesn't do. And then we begin later on page 4, starting on about line 16, we start with the definitions that go from this page to page 16, line 10. And the definitions are important in this bill, no question about it, because we are deciding what we believe to be, the things that are needed for a woman to truly understand as it concerns the procedure she's considering, or if it's a chemical abortion, the things that relate to that. So it's covering both those types, a surgical abortion and a chemical abortion. And so if we kind of go through some of the definitions, some I'll just point out to you as we go, is the idea of coercing an abortion. Like, what does that mean? And then we have the definition of coercion specifically, and then complications. What does complications mean? You see there's a definition of elective abortion. What does that mean? And then we begin with what I think is a significant part of the bill is page number 10, line 19. We begin to define what is informed consent for purposes of this private right of action of a woman. And it's a written statement. That's may become important to understand that it's written. We're not compelling someone to say something they don't want to, and we can talk about some of those constitutional issues. We have an expert online that to address any questions you have about those, but it tells you, in fact, what is the adequate and necessary information that a woman should have before she makes the decision. So we move on, and we then define interested party. And I will say, I note that because when we get to the cause of action and it says any interested party, I will be referring you back here. This is what it means by any interested party as far as who can file suit on this private right of action. So I also note on page 15, line 5, liquidated remedial damages that we have in the bill. We can talk a little if you want about liquidated damages and what they do, where you see them in the law, but it's common to have them where you're defining the damage by contract, or where as a public policy, we decide a certain amount should be awarded based on maybe claims that are not easily been able to show attach a monetary amount to them. And that's what you're going to see here. So as we move on to page 16, is where we begin with this private right of action. And you can see there that's where you see the interested party that's defined on page 14, may bring a civil action against any person who performs an elective abortion where the interested party was harmed by the performance of an elective abortion and the pregnant woman. And then there are 3 situations given. And notice this is or. So any one of these could trigger the right of action. All 3, you could have more than one basis, could be included in the private action as well, but one of the 3 is enough to trigger the right to go in and file a lawsuit and have a court determine if, as a matter of fact, she was harmed, that things occurred and that she was harmed. And so, and we see then where we get into the area of damages. And again, it's important to realize these damages only happen if harm has been proven in a court of law. There's no automatic. Once the harm has been proven, then the trier of fact, whether it's the judge or the jury, says, yes, there's harm. Then they turn to looking at damages. And this is where you see this idea of the liquidated damages. And the concept behind this is sort of that emotional thing, the stress and difficulty that a woman can face if she's been harmed. Part of it's just what happened to her, and a liquidated amount of $25,000 for that. And then if she can prove any additional damages, it would be compensatory damages that would be decided by the trier of fact, but the court can always determine whether those are reasonable. If you go on to page 18, you see there's a statute of limitation. I want to point it out to you because the typical tort statute of limitations, 2 years, sometimes we see 3 or 4 years, so there are torts where we have said, look, in this situation, factually, there's a justification for a longer period than the traditional 2 year. And this is one of those situations. And here's why. well, there's a couple reasons it could happen, but one relates to there could be some immediate harm. And but there's some of this harm that may have to do with some things like that would happen later. Like if a woman may have some things that happen to her and she's not able to have another child, which is part of the informed consent. And a lot of that harm has more to do, and again, the experts will talk about this with gestational age of the child when the abortion was had. So this is part of the information they're supposed to get. So in some cases, it could be farther until they try to have another child. That's one example. In the coercion space, we know women who might be coerced in relationships that are unhealthy. It might take a bit to be able to be in the place where they could say, look, I was coerced and these are the facts that happened. And so we've given it some more time, but that's a public policy decision. And then let's see, there's a section about free speech on page 19. And then there is in this bill a right of intervention. And I want to talk to you a little bit about that. And typically I've not been a big fan of rights of intervention, but I've tried to put some sidebars on this. But one of the reasons that I felt it needed to be done is because some of the Supreme Court's decision really talked about a couple things, but legislative finding and legislative what we do here, and then what was happening at the trial court, and that the state did not prove this, the state. And so I don't necessarily disagree with the conclusions the court made, but that's where it kind of gives rise to, does the legislature have the right to sort of explain or defend the laws they've made on their own merit concerning their own intent and why they did it? So I feel like the court opened the door for that. It never breached really separation of powers. I mean, if we thought that, then how can the judicial branch submit a budget to us and we get to say whether they have the money or not? Like, the branches always interact. And this isn't about one being superior. It's about the legislative branch being able to defend and bring to the court, the trial court level, and I'm talking about the facts that they feel support what they did and when they passed the legislation. So that's why now I feel like we do need to look at that, because I think there might have been some different outcomes, maybe not completely on the case, but would certainly have been some different evidence at the trial court level. So this requires a joint resolution before that anyone can be appointed to basically be the person who intervenes in the case from the legislature. There has to be a joint resolution. So both houses have to pass by 2/3, agree that that's a good idea in this case. That's the first sidebar. There has to be a joint resolution. There's no outright right to intervene. And secondly, only on constitutional issues, not any other types of cases. So that is limited to that. And I really wanted to point that out so we didn't get too far afield and not understand that that's very deliberate to keep it within those confines. And there's on page 21, there's a provision that basically says that these provisions of this law would also apply to people who are employed by the state, doctors who are employed by the state. So, and that could be in the prison and different state facilities, that it would, and it's really, this is putting into a statute that already exists, 139, 110, about liability for healthcare workers, and simply adding this language. You see this, at least on my copy, it's in red, but for the purpose of this subsection, medical malpractice includes a violation of, and this is the statute. So we're just saying, that's how we pull it in to those that are employed by the state, because they're under a little bit different statute. So effective date, you see there, July 1. And with that, what I would say, Madam Chairman, is we do have some experts, and Dr. Lind is here, but it may be that that Dr. Wheeler is kind of between getting on airplanes and off airplanes. And so maybe we go to her first and then we come back to Dr. Lind.
Thank you, Representative. Just one moment. Senator Hutchings had a question. Is it a quick question?
No, Madam Chair, I'm going to allow this doctor to speak since he's on his way. We'll
Okay,
get to it
all
later.
right. Thank
Thank
you
you.
for that,
Thank you.
Senator. All right, go ahead with your expert witnesses and all. We'd like to admit Dr. Wheeler first.
Yeah.
Thank you, Dr. Wheeler, for coming to us from the airport. We really appreciate your time today.
Thank you, Chairwoman. And I'm sorry, if there's an overhead announcement, I'll just pause for a moment. Madam Chair and members of the committee, I'm Catherine Wheeler. I'm a board certified OBGYN physician. I practiced 24 years in Utah and now reside in Colorado. As part of my practice, I performed abortions. I testify on behalf of myself and I ask for a yes vote. I want to thank the bill sponsor. Informed consent is a cornerstone of medicine for ethical care and shared decision-making. While some may say that this is already a standard in medicine, it is actually not being consistently applied. Policy does not mean practice. When medicine does not police itself, the law must step in to ensure women's rights to make fully informed decisions are upheld and the women are protected. When they're harmed due to incomplete informed consent, their right for redress must also be protected. It is the sole responsibility of the physician to ensure that true informed consent is provided, that she has all the information she needs to make that decision, that all of her questions are answered, that she understands the information and ramifications, and that she is signing voluntarily with no coercion, duress, or intimidation. I hear consistently from women who've had abortions, they didn't tell me that, I didn't know. What they told me would happen isn't what happened. Many tell me stories of coercion, and I consistently hear I had no choice. My training and practice for informed consent for abortion was different than that which I provided for all the other procedures I did. There were details about the procedure I didn't explain, and I certainly did not explain the details about the baby, all under the guise that it would be too hard for her. This is wrong. This is paternalism. When I performed a hysterectomy, my intention was to remove the uterus. I gave her all the details she needed. When I induced abortion, the intention is just not to end a pregnancy, but according to the CDC, is to intervene to end a pregnancy with a result other than a live birth, meaning the baby can't survive. I did not tell women about that part. There's a power dynamic and perceived authority in medicine that already can put a woman at a disadvantage. Incomplete disclosure is especially egregious as it may be driven even by a provider's unconscious bias about what's best for a woman without fully engaging her in her decision-making. I hear consistently from other ex-abortionists, abortion workers, and women who've had abortions that informed consent in the bigger abortion facilities are often done in group settings, overseen by a non-medical employee, not between her and her physician. She typically meets the abortionist the first time when she's actually in the procedure room, a time when it's really hard to back out. Abortion is a woman's choice only if she fully understands what she's choosing and the alternatives. I ask on behalf of women for a yes vote on House Bill 117, and I'm happy to answer any questions you have.
All right, committee, are there any questions for Dr. Wheeler? Any questions? All right, we don't have any questions here. Thank you for your time today.
Thank you.
All right, who would you like to call next? Representative Lawley?
Dr. Lynn, please.
Dr. Lynn, welcome, Dr. Lynn. Thank you for being here.
I'm Dr. David Lind. I've practiced OBGYN in Cheyenne for over 33 years. And I'm speaking on behalf of the bill, obviously. Providing quality care is important to everyone. And the mainstay of quality care is informed consent on any procedure that's going to be done. And the major things that accomplishes, it allows a woman to know the crucial details of any action that's going to be taken. It creates safeguards to allow the woman to have appropriate descriptions of the proposed procedure, the outcomes, and the complications. And more importantly than anything, it establishes a doctor-patient relationship. So if a complication occurs, she knows who to call. And that's real important, and that doesn't happen in some aspects of abortion care, especially when it's medication that's obtained online. The types of procedures all have different rates of complications depending on the gestational age of the infant, and so this needs to be elucidated in that informed consent. Surgical abortions are easier and are less risky at an early gestational age. When you get later towards viability, they become more complicated. They have more complications. Even medication-induced abortions have different rates of success and failure. They're more successful if given within the 10-week time frame that RU486 and
Yes, hang on just 1 minute. Senator Stein.
Madam Chairman,
Senator Scott.
can I ask the gentleman to speak a little closer to his microphone? I'm having trouble hearing him even with my hearing aid.
All right, thank you. Could you please just pull that forward a little and speak a little louder?
Yes, Madam Chairman, thank you. I'm sorry, Senator Scott. The, with medical procedures, the RU 486 followed by Cytotec is prescribed as FDA approved up to 10 weeks. When you get outside of that, the failure rate of accomplishing what was intended to accomplish becomes higher. There becomes a greater likelihood of retained products of conception and things of that nature. Some people use Cytotec alone, misoprostol alone, and that has a lesser rate of effectiveness. And others use methotrexate, which is not indicated for termination of pregnancy in this sense. With adequate informed consent, the type of treatment needs to be specified along with the complications, depending upon that gestational age. These include failure of the treatment to terminate the pregnancy, the creation of hemorrhage, infection possibly leading to sepsis, uterine perforation, and damage to adjacent structures, even the possibility of death. Adequate informed consent also requires description regarding alternatives to treatment, including no treatment. The bill also includes a time limit of at least 24 hours before the procedure would be done after the consent is obtained. And this is something that in testimony on the House side, people said that they've never seen that in any procedure. But when we sign consents for a woman to do a tubal ligation and they're on Medicaid, there's a requirement of a 30-day wait period. And that 30-day wait period is there to allow a woman to change her mind, allow her to have the opportunity to ask questions, to consult with friends and family and whoever she wants to consult with, and to decide not to have the procedure done if she so chooses. And the wording in that consent is structured in such a way as to make sure that they know that they won't lose federal benefits if they choose not to have a tubal ligation. So those kinds of constraints are built into other bills. So this one would literally do that as well. The ideal situation is to have a consent signed at some time prior to the procedure, at least a day or so out, if not even a week or 10 days or more, to allow people to have that opportunity to make decisions as to what's appropriate for them. The assessment of the gestational age is really important in providing an adequate consent, in providing an adequate treatment for abortion care. And that can be done, I guess, on the table, but it should be done in advance so that people have an understanding of what they're really getting into. I think that it's really important that we provide quality care for women in Wyoming. And so I would urge that we vote yes for this bill to provide adequate informed consent. Thank you.
Thank you, Dr. Lind. Are there any questions for the good doctor? Any questions? Seeing none, thank
Thank you.
you. Representative Lawley, did you have anyone else?
I believe online we have Danielle Pimento, and then also Dr. Dean Bartholomew as well.
Okay, Danielle, would you happen to be ready to go online? We cannot hear you. Your mouth is moving, but there's no sound. We'll give you a couple more minutes. You are still muted. I don't believe it's on our end, is it, Clayton? All right. While you're getting that worked out, we'll come back to you. Let's go with the next person we've admitted. Senator Scott.
Madam Chairman, at some point, I'm going to want to come back and ask questions.
Yes, as soon as her experts are done, we will go back to Representative Lawley for questions. Senator Hutchings has been holding one as well. Did we have someone else online? Okay, Mr. Bartholomew, Dr. Bartholomew. Welcome.
Can you hear me?
Yes, we can.
Thank you, Madam Chair and esteemed committee members for the time this afternoon. I'm Dr. Dean Bartholomew. I'm a family physician in Powell. I'm speaking in favor of House Bill 117 addressing informed consent for Wyoming women. We're going to hear testimony today that informed consent is being given in Wyoming, and I believe that is the case, especially for those who have a physical presence in the state. But I rise in concern about women receiving treatment from out of state and through our telehealth networks. Has been well documented in the legislature in the last several years in discussions surrounding the use of ultrasound and medication abortion. The medical community has gone from requiring the use of an ultrasound to confirm pregnancy location and dating to now removing any requirements for determining pregnancy location and dates, and also not requiring an in-person visit with a provider for medication abortion. But rather the woman who suddenly may be in a chaotic situation, an unexpected pregnancy, and possibly a coercive situation, can have a telehealth visit and have pills mailed to their home. Not because we had great studies showing that this was safe, but that was determined during a pandemic, and the abortion movement's absolute commitment to abortion access pressed that fact. After the case, the abortion industry is now stating they have studies showing that telehealth abortion is safe. But there's also other studies really questioning the safety of medication abortion in the numbers that they quote. So my concern today is really for the women of Wyoming who are receiving mail order pills. Are they receiving true informed consent, or are they really just checking a box on a website, much like you and I do when we check on the terms and conditions boxes on websites before those pills are mailed in? What if the woman is being coerced? What if the woman is being trafficked? What happens if this woman has complications? Well, we know what happens. They show up in our hospitals and in our ERs. And I can give you personal stories from our local pregnancy center if you want to hear those later. So if we're going to speak of women's freedom of choice, let's make sure she truly is reaching a choice that is right for her, free of coercion, and is fully informed. Thank you for your time, and I stand for questions.
Thank you, Dr. Bartholomew. Any questions for the good doctor? Seeing none, thank you so much.
Thank you.
We have one more. We'll go back to Dr. Danielle if she's available and has volume. If not, we'll go back to questions for Representative Lawley. I don't see her on anymore.
Can you hear me? I'm on. I'm just trying
Yes,
to.
we can hear you. All right, go ahead.
I'm so sorry. My camera's not working, and I apologize. But I'm happy you all can hear me. I had to switch over to my phone, but
Right,
thank you.
just let us know who you are and if you're with someone or speaking on behalf of yourself.
Absolutely. Good afternoon, members of this esteemed committee. My name is Danielle Pimentel, and I serve as policy counsel at Americans United for Life, which is a national law and policy nonprofit organization that specializes in abortion, end-of-life issues, and bioethics law. And I want to thank you all for the opportunity to speak today. And I want to focus my time on the constitutionality of this bill. And as you've heard from Dr. Wheeler, Dr. Lynn, informed consent is a cornerstone of modern medicine, and elective procedures merit heightened informed consent safeguards. And this is exactly why the U.S. Supreme Court upheld heightened informed consent protections for women considering abortion in Planned Parenthood versus Casey, also finding that informed consent safeguards like the ones in HB 117 do not compel speech. And even today, a majority of states have heightened informed consent protections for women considering abortion. Wyoming likewise can enact HB 117 to protect a woman's informed consent by recognizing her right to receive all relevant facts before deciding whether to have an abortion and giving her the tools to hold a physician accountable if they fail to provide those required safeguards. And furthermore, HB 117 falls squarely within the constitutional bounds laid out by the Wyoming Supreme Court in State versus Johnson, which recognized a right in the state's constitution to make one's own healthcare decisions, including the decision to have an abortion. And HB 117 does not infringe upon this right because, as you've heard from Representative Lawley, it supports women in making pregnancy decisions and is consistent with the state's fundamental right to make one's own healthcare decisions. Ultimately, women are entitled to a basic standard of care for medical professionals, including the right to receive information about a medical procedure's risks and alternative options. And that's what HB 117 seeks to ensure. And the bill, as I mentioned, survives the strict scrutiny test laid out by the court in State versus Johnson. And under this test, an abortion regulation has to first further compelling state interest, and second, be narrowly tailored in order to achieve that interest through the least restrictive means. And HB 117 ultimately passes this test by empowering women with authentic choice. And it does so first by furthering the state's compelling interest in protecting a woman's right to be fully informed before undergoing abortion and ensure that she has consented to this medical intervention. And furthering this interest of safeguarding women's informed consent is especially important for the state, given the rates of coerced abortion, which is shown by studies before you in the findings, as well as you've heard personal examples, even from Dr. Wheeler today. Second, the bill also is narrowly tailored to achieve the state's interest in safeguarding informed consent. And it does so by directly equipping a woman to vindicate her own right to receive certain medical standards of care from her provider without interfering with the state's constitutional right to make the underlying healthcare decision. So the bill narrowly tailors its requirements also to only apply to physicians performing elective non-emergency abortions. So it does account for medical emergencies. And the bill grants a private right of action only to the woman who was harmed or an interested party in the event of her death or incapacity. So ultimately, HB 117 empowers women, not the state, to enforce her own right to informed consent without needing a state actor to vindicate her rights for her. And thus it satisfies strict scrutiny and is constitutional. And thank you so much. I'm happy to answer any questions.
Thank you, Ms. Pimentel. Any questions? Questions from the committee? Seeing none, thank you for being with us today. We'll go back to Representative Lawley. I believe Senator Hutchings has the first question.
Thank you, Madam Chair. Representative Lawley, as I listened to you deliver this bill, transformation happened with me where I see more that this bill deals with young ladies who've been coerced into having an abortion. It's not dealing with so much someone who gets pregnant and just walks into their doctor and says, I want to abort. This is dealing with young people, trafficked women that may, like you say, be forced. So on page 18, I was concerned about on line 20, I have the 5-year mark there. That's where we were talking about kind of a statute of limitation. It seems to me if there's, and it happens, a young lady's being raped by her father, brother, someone in the family, she could be 13 and severely harmed by that abortion. So we're only going to give her 5 years, and that's kind of like till she's maybe 17, 18 to bring a course of action. It seems like we'd want to give them a little bit more time so she'd be out of the house and away from that offender if that's the case. Does that make sense, or am I reading this wrong?
Representative?
Thank you, Madam Chairman, and thank you, Senator Hutchins, for the question. It's a policy choice, and you are balancing the idea of, how long should that go? And to the specific example that you gave, Senator Hutchins, is there are, again, the other interested person could be someone to act on behalf of a minor, to come in on their part and to file a claim on their behalf. So there are ways to address that through that process, is having someone who maybe has taken over care of that minor relative in the family and could do that. Of course, in your specific example, 5 years should be 18 and could come and do that on her own. But I think that you have to see the statute of limitations is always about balancing policy, about what's needed, but not too long, because it keeps, those folks who are, might be pursued under this, that time passing has an effect on them too. So that's why that was put at 5 years.
Okay.
All right, follow up?
Follow up. So if my brain, I can remember what I was gonna say. Let's come back.
All right,
Kind
we'll
of
come back to you, Senator Scott.
in my mind.
Yes, go ahead.
Quick
Go ahead.
Yeah.
I believe, Madam Chairman, in line or page 18, line 18. I think that has to do with lining up that 5 years with other parts of our statute. So there's not like these one-offs all over the place. So I
Gotcha.
think that 5 years kind of falls within that. Thank you, Madam Chairman.
Thank you, Senator Crum. We appreciate that. Senator Scott?
Madam Chairman, yes. Two questions. First, on page 21, lines 2 through 5. Is it the intention of the sponsor that the state is going to wind up intervening in individual cases all over the state? And how does the state find out about them? I'd like a little more information on this particular, why this is here.
Representative, go ahead.
Thank you, Madam Chairwoman, and thank you for the question, Senator Scott. What this is, the only time this would come into play if this statute that we're looking at now, this bill, were to be challenged in a court based on constitutionality. So it's for this, it's not a open-ended intervention into anything. It's for this bill. It says that you can, through a resolution, 2/3 vote of both bodies, they could appoint a legislator or legislators to represent and defend, if you will, the bill that was passed, the law that was created by this legislature, if it's a constitutional challenge to this bill. But it's not other cases. These are private rights of action. There's no interfering with those. It would be this bill itself that created the private right of action somehow on a free speech. If someone comes and says that this violates free speech, you heard from our expert, it does not, and the reasons why. But I'll just say that that's what it's doing. For just if this particular law we're looking at passes and is challenged on constitutional grounds.
Follow up, go ahead.
So it's somebody to intervene in a court action over on the issue of the constitutionality of this bill.
Correct.
Okay. Madam Chairman,
Go ahead.
there's an extensive purpose clause in this bill. And over my years here in the Wyoming legislature, we've tended to remove purpose clauses. And we still put them in sometimes particularly when attorneys advise there's a problem and you may need it will help a court case. What is there in this bill that why do we need a purpose clause? Why don't we just take the purpose clause out?
Representative, go ahead.
Thank you, Madam Chairwoman. Again, thank you for the question, Senator Scott. I think because this bill can be misunderstood in a way for people that aren't familiar with the law and the creation of private rights of action. So the purpose clause does just clarify what our purpose is as a legislature, what we're doing and kind of the basis for what we're doing it. But again, that's up to the committee, whether they feel that that's not helpful or could cause a problem. I don't use finding, usually when something is explained or a purpose given is sometimes helpful for those who come after and say, why did they do this? What were they thinking? So, but again, it's really up to this committee.
Senator Scott, you good?
No, I'm sorry, I don't think it's a good idea, but I'm not going to fight over it.
Okay, I'm gonna go to Senator Crum next. I see he's reaching, and then we'll come back to Senator Hutchings.
Thank you, Madam Chair. I had the exact same two questions about the right to intervene and then the purpose clause. But back to the right to intervene, Madam Chairman, my question would be, wouldn't the state already, because this would be a statute of law in the state, wouldn't they already go to defend and be a part of the legal proceedings anyway? So I guess I'm coming back to the right to intervene. Why do we need this when the state would already step in and participate in this?
Representative.
Thank you, Madam Chairwoman. Thank you for that question. It's a good question, and it goes back to my explanation about, because you're correct. The Attorney General's office will be the primary defender in general of the law. But what we saw from the opinion by this recent opinion by the Wyoming Supreme Court is some pointing out of, maybe it was short of criticism of, how the state prosecutor, the Attorney General's office prosecuted and defended the law. In other words, this wasn't established by the state. This wasn't established by the state. That was established by the state. And that, for me, it raised the question, is it maybe not appropriate for us in constitutional issues to explain ourselves, so to speak? And so that's why the right of intervention is, I couldn't help when reading that opinion of thinking that, well, I think they made a good point in terms of what was lacking. But the question is, had legislators been able to intervene? And again, under these conditions, not an outright intervention, but with a 2/3 vote of both houses. So they kind of agree, yeah, we need to explain and defend what we did when we passed this law. And that honestly, before that, I tended to not prefer these types of, and that's why I put sidebars on them. 2/3 vote, a resolution, and secondly, it must be challenged under on a constitutional basis. And I think with those restrictions, what we know happened, that's why I would support having this kind of an intervention clause in it. So.
Very good. I am going to comment on that because in the Life as a Human Right Act, we did have the right to intervene on behalf of that bill. It was taken out. And then our legislators that were trying to intervene in that case were denied that ability to do that. So I think this is a very important component of this bill. And I know it's not the same legislation, it's completely different, but that has happened in the past. And so now we'll go to Senator Hutchings.
Yes, she's regained her composure. And the question was about something we hear a lot, the doctor-patient relationship. But as you were going through this bill, in my mind and listening to the various doctors, there really isn't a relationship formed when you're coerced or forced to have an abortion, a young lady, parents, whatever. And the harm that can come from not having that patient relationship where they're informed about all the details, like he mentioned, damage to structures that may not be seen for years. The child grows up and can't have a child because something that happened during that forced abortion. Is that kind of where you're going with this bill? There really is no doctor-patient relationship. They've just been brought in. You're going to have this abortion. You may not get a complete conformed consent because you're 13 again or 14. You won't even understand what's going on. Your parents may get it, but you don't get it. Is that where you're going?
Representative Lawley.
Thank you, Madam Chairwoman, and thank you for the question. I would hesitate to really say all these situations are the same because I think that's not fair to say they're the same. What we're getting at is where for whatever reason, there wasn't adequate informed consent, A, and secondly, that a doctor knew or should have known, which is a common standard we use in tort law, a reasonable person would do in the same and similar circumstances. So knew or should have known that the woman was being coerced, which is no different than doctors looking out for elder abuse, child abuse. I mean, they see signs. They're not responsible for what they didn't know, but if they should have paid attention, if there was something there that was noticeable and would have caused them to maybe ask a few more questions, because it really is the doctor's responsibility. Is this consent informed? Does a person have the ability to give consent? That's competency. Did we give the adequate information? That's part of the adequacy of the information and for the consent to be given based on that. And then what was it? Was the consent coerced? Was it given a free will? That almost operates in every type of contractual relationship, quite frankly, the same ideas. But that's what we're getting at in this bill, and to protect women, giving them the ability to protect themselves. This bill creates a tool for women to protect themselves, to say, this is what I'm entitled to. I want to know. I want to understand potential things that could happen in the future. And then I also want my doctor to notice when it appears that maybe I don't want to do this. And sometimes it's the behavior of the woman. Sometimes it's the behavior of someone that accompanies her to the appointment. So we're just saying these are important aspects of informed consent and women should be protected. But we're not saying the state should police this. We're saying that a woman should have a right of action in order to enforce and protect herself. And that's really the bill.
Thank you, Representative Lawley. Going once, going twice, seeing no further questions, and thank you to all your experts that you brought today to inform the committee. With that, we will go to public comment and go ahead and come on down and fill the chairs. I'll remind you that it is a 2-minute time limit and Clayton will be timing that. So come on down, give us your name, who you're with, if you're with an organization, and I will turn the committee back over to the good chairman.
Thank you, Senator Steinmetz, and thank you for being acting chair. Go ahead and if you'd state your name for the record and give us your statement.
Thank you, Chairman. My name is Dr. Renee Hinkle. I'm an OBGYN physician in town for 27 years. And I'm speaking against this bill, mainly a couple reasons, but the main one is that it's really not necessary. Informed consent is a legal, it is legally binding, and physicians are held to that standard all day, every day. We are kind of the experts in informed consent when it comes to this, and we start training on that from day one of medical school through residency. So we talk about informed consent all the time. If the legislator who brought this bill and those who have supported it are so concerned about harm caused by lack of informed consent, why is this only for abortion? Why is it only for women? The concerns about informed consent that they presented can be problems with informed consent for any procedure. So why not make it a general, a law that people who feel like they're harmed from a procedure that they haven't had full consent for. So this is really a law making the rights of women harder to get, not easier. The bill itself really is coercion. It's making women have to go through different hoops to be able to have a procedure performed. And so, telling women basically that they don't know what they want to do, that they have to get special informed consent that is not the same with any other procedure. Informed consent means that maybe they're not smart enough to understand it. Maybe they, the person, that's enforcing this wants them to think about a different thing that they're not doing. So if the true concern is harm to Wyoming people from lack of informed consent, then it should be for all people and not just women. Women have the right to health care.
Senator Scott.
Madam Chairman, my question relates to the circumstance where it's not a surgical operation, but where they're essentially taking pills that they've got in mail order or from some out of state source. How does this bill affect that? Does this bill essentially forbid that?
From my reading, it says that the woman can sue them if there is a problem that happens, but that can happen whether this bill is in place or not.
Any further questions? Thank you. Next.
Good afternoon, Madam Chairman, members of the committee. My name is Wendy Volk. I'm speaking as a private citizen, a wife, a mother, and a fifth-generation local business person here in Cheyenne. Every serious medical decision I've made in my life has been private, personal, and based on informed consent. Let me be clear, coercion is wrong. Negligence is wrong. If a physician pressures a woman or violates medical standards, they should be held accountable. This is not in dispute. What is at issue is how we legislate after the Wyoming Supreme Court's decision in State versus Johnson. In that case, the court held the Healthcare Freedom Amendment protects a fundamental right to make one's own healthcare decisions. The court explicitly determined that abortion qualifies as healthcare under our Constitution and applied strict scrutiny. That is binding law in Wyoming. House Bill 117 does more than reinforce informed consent. It creates an abortion-specific civil liability structure, which encompasses $25,000 minimum statutory damages, mandatory attorney fees for plaintiffs, no fee recovery for prevailing defendants, restricted defenses, and a 5-year statute of limitation. This is not neutral malpractice law. We have also need to acknowledge a larger troubling pattern here in Wyoming. Session after session, proposed legislation has focused almost exclusively on regulating reproductive decisions of Wyoming women. We do not see comparable legislation regulating the reproductive conduct or responsibilities of Wyoming men. When the law repeatedly singles out one sex's constitutionally protected medical decisions, courts will examine both the burden imposed and equality implications. If the goal is stopping coercion, it is already illegal. If the goal is stopping negligence, malpractice already applies. If the goal is informed consent, that can be addressed neutrally across all medical practices. But targeting one form of protected healthcare with punitive civil exposure invites strict scrutiny and likely litigation. If the goal is durable law rather than symbolic law, it must be narrowly tailored and constitutionally defensible. I respectfully ask you to vote no on House Bill 117. Thank you.
Thank you. Committee, any questions? Senator Hutchings?
Thank you, Madam Chair. Wendy, thank you for coming in. I appreciate you, as you know. You stated that all your procedures have been private, personal, and informed. But what about the young lady? Because we know men can't have babies. The young lady comes in and she's being coerced to have this procedure and she doesn't receive any informed consent. That's what I see this bill is about. Tell me your take on that. Thank you, Madam Chair.
Madam Chairwoman, thank you, Senator Hutchins, for your question. So I truly, from the time I was a young woman on up to now being in my 60s, I have never been coerced. And I don't think, even when I was a young woman seeking care at a Planned Parenthood clinic, did I ever feel coerced. They gave me information, they gave me resources, and I appreciated that. And then I was able to take that information and weigh what that was going to be on my life. And that is also what I would think all Wyoming women and daughters do. I have not had the opportunity to meet someone who said this happened. I did hear at last week's rally, however, there's been forced sterilization of women in Wyoming on our reservation, and that was troubling. There's a troubling pattern there. I wish we could, change history, but I'm not seeing that this is something we need to get into the weeds in as a legislature and as a society when there is already, I think, rules and regulations in place. I think we're really targeting and getting very specifically into women's reproductive health care. And I just don't think there's a place for it. Wyoming appreciates having privacy. I think every pregnancy should be very respectfully handled with privacy and dignity, and it should not be public. I don't want our legislature interfering in my daughter's healthcare decisions. I don't want them interfering in Wyoming Sun's healthcare decisions. But I think once we start that, we're going down a very slippery slope, and I think it's setting a very poor example as our Constitution is set up to protect individual healthcare decisions.
Thank you. Next.
Madam Chairman, I'm Fred Harrison, and I represent Wyoming Right to Life. And I also appear on behalf of myself, and I'm going to say some things about some personal aspects of this. But first, I want to address what Senator Scott brought up. And Senator Scott brought up that what about chemical abortions? Can this act be enforced across state lines? And the answer to that is yes. And I'm on and for the bill. And that's because this is a individual lawsuit that is brought by an individual citizen in the state of Wyoming for the lack of informed consent and the damages caused by that. And that becomes a judgment. And that is enforceable across state lines because it would be, you would have to invoke the jurisdiction of the other courts, but because of the full faith and credit clause. And for quite some time, I think since 1896, that has been the law of the United States, that those judgments are enforceable. And so this would be enforceable. And this is really better than if the state imposed a penalty, because if it was a penalty, then there would be a question as to that, whether that could be enforced across state lines because of the full faith and credit clause of the United States Constitution. So that's the problem. And I think this bill addresses that quite nicely and has been shown to be enforceable in other states, such as Texas, where they have similar patterns of statutes. So I just wanted to bring that up. I want to address a couple of other things. Historically, and I'm glad you brought up also the other lawsuit in this case about the Human Life Act. I was involved in that case. Initially, I filed an amicus brief on behalf of the legislators, several of the legislators, and that brief was not accepted by the Wyoming Supreme Court. And also physicians in favor of the Human Life Act also filed an amicus brief that was also rejected by the court. And I also talked to the Attorney General's office, and my direct request was that they present—
2-minute limit and.
Okay. Was that I'll finish up then, was that they present evidence, because I knew that was going to be a problem in front of the Wyoming Supreme Court, and it was. There's a lot of other reasons to support this bill. I wish I had more time. I've spent a lot of time on the bill. I think it's a very good bill. I would urge your support.
Definitely. Thank you. And Senator Steinmetz.
Thank you, Madam Chairman. I just have one question. You said there are a lot of reasons that you support this bill. What are the top two?
What are the top two? Well, the main one is I think that it will survive a strict scrutiny test. And I think the reason it will survive a strict scrutiny test is first of all, what is a strict scrutiny test? It was an invention of the United States Supreme Court in Komatsu. It's the first time it was ever used. It was used to lock up Japanese citizens. That's when it was first used. After that, it then progressed up and finally ended up in Roe versus Wade, strict scrutiny. It is an invention of the courts. But even as an invention of the courts, I think that this statute survives it because of the compelling interest, because this statute is based on historical precedent that goes back to the Nuremberg trials in 1947. And I put that in my amicus brief, by the way. And so this was a historically relevant from the standpoint that informed consent has been part of medicine forever, since the Hippocratic Oath 2,500 years ago. And incidentally, which said first do no harm and then don't procure an abortion, was a part of the Hippocratic Oath. All that went out the window with Roe versus Wade. And this statute answers that informed consent. We didn't have any informed consent in this country on abortion until Planned Parenthood, Planned Parenthood versus Casey. And then we had it. But at that point, before that, we got into this bad habit of no informed consent for abortion because strict scrutiny prevented the states from passing laws on informed consent on abortion. And they were repeatedly struck down by the courts under strict scrutiny. This bill puts the courts in the position that they can't really defeat this bill, I don't think, because without embarrassing themselves further than they have already in this case, because they would have to lash out against informed consent. And the reason this bill is a good bill is because all it requires is the truth. And that's what we want. We want women to have the truth, and the truth will set us free. Thank you.
Thank you. Welcome.
Thank you, Madam Chairman, committee members. My name is Britt Borrell. I am Executive Director for WYO United. We are a nonpartisan organization that is focused on advocating for reproductive freedom and expanding access to reproductive care in Wyoming. Contrary to its title, I find this bill to be offensive and disempowering to women. As previously stated, it is also unnecessary, as equal informed consent should be applied to all procedures. This bill pushes government overreach into our doctors' offices and treats women as if we cannot be relied upon to make our own medical decisions. I would argue that is actually paternalism. This bill dishonestly claims abortion seekers are usually coerced in their decision-making and should therefore be required to wait 24 hours to receive care, a limitation placed on no other procedure in Wyoming, at least for men, apparently. I sent this committee an email with links to the studies cited in this bill explaining why they are flawed and do not support the coercion claim. One such citation is a review of comments made by self-selected women who sought counsel from religious anti-abortion centers. Anyone conducting a study with a degree of scientific rigor knows that sample sizes must be randomized, not self-selected. And I sent the committee members one such reputable study as well. This bill also cites a 2023 study and implies that because 60% of women experience pressure when seeking abortion care, they must be coerced. However, the highest external pressures reported in this study were financial and life circumstances, not partner coercion. So really, this study shows us that providing economic safety nets for families could actually reduce abortions. The penalties for healthcare providers are also unreasonable. Harm is defined so broadly here that it would likely deter OBGYNs from practicing in our state when we're already experiencing care deserts. If a provider should have known of coercion, someone could seek damages of at least $25,000. Surely, if coercion were present, damages should be sought from the person who coerced, not the provider. No one is implying that abortion or that the decision to seek an abortion is easy or free from external or internalized pressures. I don't know a single woman who has entered this decision lightly, but they all weighed the alternatives for themselves and made the decision that was best for them and their unique circumstances. Wyoming women deserve to be treated with dignity and respect by our government, not constantly confronted with barriers to care from lawmakers who don't think we are capable of making informed decisions. I ask you to please vote no.
Thank you. Right. Welcome.
Thank you, Madam Chairwoman, members of the committee. My name is Mike Lehman. I'm with the Catholic Diocese of Cheyenne. I've listened to a lot of debate over the last 10 years on this issue. And I always encourage folks to listen to the debates on the floor and before committee because there's some great points being made on both sides of the question. Generally speaking, the best points made on the other side of this question comes from hearts that are genuinely concerned about the life, health, and rights of women. I say we should listen to the best of their points so that it informs the development of legislation so that the best possible bills can be presented moving forward, but also listen to what they don't say. For instance, listen to how any mention of the life, health, and well-being of the preborn child is avoided at all costs. Listen to how any mention that the procedure has significant risk for the mental, physical, and spiritual health of the mother is avoided. And ask if informed consent depended upon that testimony, would it really be informed? For 50 years, our culture has done much to destigmatize abortion. As a result, many women who find themselves in less than ideal circumstances discover abortion doesn't really feel like a choice. It feels a lot like an expectation. And it comes from the pressure of boyfriends, husbands, parents, siblings, friends, and even employers. All the while, the state has stood by washing its hands of responsibility. The good news is this bill, as mentioned, doesn't ask the state to do much. It simply opens an avenue to women in such circumstances to know that they're not alone and they have some recourse should they be coerced into this decision. And finally, Madam Chairwoman, there's nothing radical or extreme about efforts made to protect vulnerable women and their babies. And with that, I would stand for any questions.
Thank you. Committee, any questions? Thank you. Welcome.
Thank you, Madam Chair and members of the committee for the opportunity to speak in support of this bill. My name is Krista Reister and I'm a private citizen. I'm also Wyoming Family Alliance's pro-life liaison. This bill has been described as paternalistic by those in opposition because it requires informed consent and a waiting period before an abortion. I respectfully disagree with that characterization. In every area of medicine, informed consent is foundational. We do not consider it insulting to require thoughtful reflection before a major surgery or a significant medical intervention. We consider it responsible. Abortion is a life-altering and irreversible decision. It should meet at least that same standard of care. That is true respect for her autonomy and well-being. This bill does not presume women are incapable of thinking. It affirms that women deserve the respect of being fully informed about the medical risks, procedural alternatives, and the nature of the choice she is making. There's a reason we often tell people to sleep on major decisions. Human beings do not make their clearest choices in moments of shock, fear, or intense emotion. And an unexpected pregnancy can bring all three. Encouraging reflection is not a statement about women's intelligence. It is an acknowledgement of human psychology. Thoughtful decision-making is not infantilizing. It is empowering. We require patients to, to understand risks and alternatives in every major medical context. A brief waiting period simply ensures that a decision made in the first wave of emotion is still the decision a woman wants to live with after she has had time to process, ask questions, and consider her options. Standardizing information and verifying that it was received promotes consistency, clarity, and accountability. It helps ensure that a woman's choice is truly her own, made with full knowledge of any medical risks, alternatives, and available support. That is not paternalism, it is respect. Respect means giving women complete information, allowing time for reflection, and ensuring freedom from coercion. This bill affirms that women deserve nothing less. I respectfully urge an aye vote. Thank you, and I will stand for questions.
Thank you, committee. Any questions? Okay. Welcome.
Thank you, Madam Chairman. My name is Katie Gieser, and I'm a citizen of Cheyenne. It seems that many people, when discussing this issue, are adamant about placing abortion on the same level as other medical procedures. They will say that we already have laws which require informed consent, and so more specific laws that pertain to abortion are unnecessary. Nothing could be farther from the truth. Abortion cannot be called just another medical procedure. It involves another human life, not just that of the mother, and in fact, the decision to end that life. This is a much more serious decision and procedure and worthy of extra processes and time. If ever there was a situation where it was necessary to ensure that the appropriate amount of information is given to the woman, it would be in this case. Please vote in favor of this bill. Thank you, Madam Chairman.
Thank you. Any questions? Senator Hutchings.
Madam Chair, I just wanted to thank Katie for coming up and giving her testimony because our Declaration of Independence states that we have unalienable rights to life, liberty, and the pursuit of happiness. And to secure these rights and the right of life, no matter what stage, who you are, it's the right of the government to, governments were instituted by men to protect those rights. So thank you for your statements. I appreciate it.
Thank you, Senator.
Thank you. If there's anybody else in the room that wants to testify, we're going to have to cut off public comment here in the next couple of minutes so that we can work the bill and get to other bills. So I'll take these two people on this bill, and then we're going to close public comment so that we can work the bill.
Thank you, Madam Chairman. My name is Linda Burt. I am here representing Wyoming Right to Choose. I would just like to say briefly, because I think there's been some very good testimony on this bill in terms of the kind of problems this bill does have. I think that there's only one purpose in this bill, and I think that that purpose is as a barrier to abortion. It interferes with women and doctors, and it assumes and implies that women are not capable of making these decisions, that somehow women need the state of Wyoming and legislators to direct what their decisions should be and how they should be given that information. It also assumes that doctors don't give that information appropriately. It assumes that doctors are not professional, that they're not ethical, and that they are not giving appropriate information to individuals. And I don't think there's any indication that women in the state of Wyoming, at least in this area and many others, are not getting the appropriate or quality care in Wyoming. Unfortunately, we have problems in terms of reproductive health in the state, and I hope those can be solved. But as far as the doctors and the kind of professional and ethical concerns that they're carrying out, I don't see that as a problem. The waiting period is a barrier. It's nothing more. Women are intelligent enough to get their own information, to do their own research, to speak to their providers and ask for that information. We don't need the state of Wyoming to tell us how to do this. And I don't think we need the state of Wyoming to tell doctors how to do it either. Just a couple of brief things that I did want to mention. I did go back and look at both of the research articles that were mentioned in this particular bill, neither one of those researchers said that they should be used as a general comment about coercion for women. Both of those researchers made that statement within that research. This should not be used for that. There's some excellent research that's been done by the National Institute of Health. That research is available to all of us, and it says that it's a very complex situation.
We're at 2 minutes.
All right, thank you.
thank you.
Women are often coerced in many different areas of their lives, and the coercion level for women in this area is no different than other areas. Thank you.
Welcome.
Madam Chairman, members of the committee, thank you for the opportunity to testify today. Studies from the Lozier Institute
Could
and
you give us
researchers-
your name, please?
Oh,
Sorry.
I'm sorry. Yes, I'm Valerie Berry and I'm an independent citizen, but I'm also the executive director of Life Choice Pregnancy Care Center. Studies from the Lozier Institute and researchers like Dr. Priscilla Coleman indicate high rates of pressure to abort. In 2023, study found that 62% of the women experienced at least modest interpersonal pressure, while nearly 45% reported high levels of pressure from others, such as partners or parents, to have an abortion. I am a white privileged woman. And no, I have not received any coercion about abortion, but I regularly, whether it's weekly or daily, see women under the influence of coercion. I have listened to parents holler at their children that they will have an abortion, which is illegal, but the abortion still happened. I have listened to men having conversations with women that are pregnant and saying they don't want this child, and the woman chooses abortion. So this is more, if you please, I see it in the marginalized. I see it in the poverty stricken. I see it in those that are under abuse, that are making decisions without clarity of mind. And it is common. And although I appreciate the opinions of others, I view this regularly. And so coercion is real. And it does happen. Thank you for your time.
Thank you. Committee, any questions? Okay. We're gonna close public comment. I know that were many online that were hoping to be able to testify. Please do send us your comments via email as we work this bill and it goes through the process. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Steinmetz, seconded by Senator Hutchings. Discussion on the bill.
Madam Chairman.
Senator Crum.
Couple things. I'd like to make a motion that for an amendment that we would remove, if I can get to it again. On page 3, we've heard discussion about page 3, line 6, I guess through the rest of the page, about those two studies that, they're controversial one way or the other. And really having this in the bill really doesn't become part, it doesn't, we probably shouldn't have that in the bill. So I'd make a motion that we'd remove the balance of page 3 from line 6 onward, just to remove those studies from the bill.
Senator Steinmetz.
Thank you, Madam Chairman. If it pleases the chair, would you consider bringing the sponsor up to help us work the bill?
Yes, that would be great. Representative Lawley.
Madam Chairwoman, I would like to respond to that. I would say that some of these are peer-reviewed things. They're not, maybe you might not consider them a study, maybe others might not consider a study, but, and perhaps, the committee believes that we don't have to really say that there is coercion. And I understand that, but I would at least suggest that on page 3, lines 6 and 7, stay in there. I think it would be remiss of the legislature not to take a legislative notice of the fact that some women are coerced. And there's a reason for that, because some people have said it doesn't happen, and that's not true. So I guess if that being done, I don't it's fine if you feel uncomfortable with the studies themselves. I mean, the real important part is that coercion happens.
Senator Steinmetz.
Thank you for that leeway, Madam Chairman. I'm inclined to not remove these, and the reason why, I actually know women that this has happened to. When they were young, they had parents that coerced them into getting this procedure. So to me, this is defining the intent of this body, the legislature, creating policy, and we are referring to these studies. So I would resist the amendment respectfully. I understand where you're coming from, but I would respectfully resist the amendment.
Thank you, Senator Steinmetz. Any other comments?
Madam Chairman, if it's okay with you, I would agree to leave line 6 and then through the line 7 where abortion period. I would agree to leave that, but still would move to delete the rest of that page.
Okay. Discussion on that? Okay. So the motion is that we would leave on page 3, lines 6 through the word abortion on line 7 and delete the balance of that. We will definitely vote on that. I do believe that this is an important part of the bill and in defining what the legislature's intent is, and that we have that fully in there is where I believe that we should go. But any other comments? Okay. All those in favor of Senator Crumb's motion that we delete starting with A 2017 and the balance of page 3, please say aye.
Aye.
All those opposed, no?
No.
No. Okay, that motion fails. So any further discussion on the bill?
Madam Chairman.
Senator Scott.
Madam Chairman, this is a very difficult area. And the reason it is a very difficult area, it is one area that I'm aware of where there are major differences within our society based on difference in religious beliefs. And I will say to you, quite frankly, I belong to a church that believes that the decision on abortions is a right that the mother has, and that right should not be interfered with. And I'm well aware there are quite a number of churches that feel on exactly the opposite on that issue. And, freedom of religion is one of the fundamentals of our beliefs here in the United States. And I will say, I think I've been consistent over the years that I've thought that public funding for abortions was trampling on the religious beliefs of the churches that are opposed to it and the people that are opposed to it as a matter of morality. I feel the same way about this bill. I think this bill is an attempt to coerce women that may want to have an abortion and make it harder for them to do that. I think that's trampling on the religion on the other side. So for those reasons, on and against the bill, Madam Chair.
Thank you, Senator Scott.
Madam Chair.
Senator Hutchings.
Thank you. Thank you, Senator Scott. I appreciate your concerns, but when I look at this bill, I don't see it having anything to do with religion. And the narrative about abortion is not really what the bringer of the bill is trying to get at, as much as to give women who have been coerced, forced, trafficked, the right to stand up and say, wait, I've been harmed. There's a course of action I can take via this new law. And this law, like she said earlier, has nothing to do with the state, nothing to do with my religion. It's about the woman that's been harmed. Let's give her some redress here. And that's what I see this bill doing. So I'm on and for the bill. Thank you, Madam Chair.
Thank you, Senator Hutchings. Senator Crum?
We'll try again here, Madam Chairman. I'd like to make a motion that on page 20, starting on line 23 with 35-6-403 through line 5 on page 21, that we would delete that section on the right of intervention. I just don't see the need for the legislature to get involved with intervention on this type of subject. You know, we have a court system, and if we don't like the rulings of the court, then we can pass another bill. But to get involved when the state's already getting involved defending the law, I just don't see a need for that. So I'd make a motion to delete line 23, page 20 through line 5 on page 21. Thank you, Madam Chairman.
Senator Steinmetz?
Thank you, Madam Chairman. I would respectfully disagree with my good colleague. You know, we've already had this happen to us once where we were denied the right to intervene. And I think this is a very important piece of the bill and future bills going forward. And so for those reasons, I would be opposed to that amendment.
Thank you, Senator Steinmetz. Any further discussion? Okay. All those in favor of Senator Crum's motion, please say aye.
Aye.
All those opposed, no?
No.
All right, that motion fails. Any other comments on the bill? I'm going to make a few comments on this and on informed consent. Members of the committee and others, you've heard me talk about healthcare before, and healthcare is complicated. And there can be complications in healthcare. And anytime you go in for a procedure, anytime you go to have something done, there is you give informed consent. And there's oftentimes complications and risks in anything. And this bill is important because we are asking for this informed consent in the case of abortion, and there can be complications. There can be a lot of complications with pregnancy, and there can be a lot of complications with abortions. And it is important that the physician and the woman, the patient, have a good discussion on those things, just as you would in any other, hopefully would in any other area of healthcare. So I will be supporting this bill because I think it only stands to strengthen what we already do in healthcare. That will call the roll, please.
This is a roll call vote for House Bill 117. Senator Crum.
Aye.
Senator Hutchings. Aye. Senator Scott.
No.
Senator Steinmetz.
Aye.
Chairman Brennan.
Aye.
Madam Chairman, that is 4 aye and 1 no.
Thank you. So that has passed the committee, and next up for our consideration is a House bill that has been worked in the interim. House Bill 3, Wyoming Pregnancy Center and Autonomy and Rights, and Representative Rodriguez Williams is here.
Good morning, Madam Chairman, members of Senate Labor, Health, and Social Services. It's a pleasure to be before you this afternoon. I introduced to you House Bill 3, Wyoming Pregnancy Center's autonomy and rights. This bill is sponsored by Joint Labor, Health, and Social Services. We worked this bill during the interim, and I'll just walk you through it. This bill is designed to protect pregnancy centers in the state of Wyoming from government interference, discrimination, or coercion based on their pro-life mission and beliefs. First, this bill makes it clear that pregnancy centers can't be penalized, restricted, or shut down simply because they do not provide, refer for, or promote abortion, abortion-inducing drugs, or contraception. State or local authorities may not block these centers from offering pregnancy testing, counseling, prenatal care, or childbirth-related services because of their beliefs. This bill also protects a pregnancy center's right to counsel women about all pregnancy-related care, including information about treatments that may reverse the effects of abortion-inducing drugs. Government entities cannot censor or prohibit these conversations. Additionally, this bill safeguards the center's staffing and hiring decisions. Pregnancy centers cannot be forced to hire, retain, or interview employees who do not support the center's mission to or agree to operate according to its pro-life ethical standards. To ensure these protections have real enforcement, the bill allows pregnancy centers or anyone harmed by the violation to file a civil lawsuit. If they prevail, they are entitled to actual damages. The bill also allows the state legislature to intervene directly in any court cases where the law's constitutionality or legality is challenged, ensuring the law is properly defended. In short, the bill protects pregnancy centers from discrimination, preserves free speech and medical counseling rights, defends mission-based hiring, and provides strong legal remedies to those when those rights are violated. And that, Madam Chairman, is a summary of House Bill 3.
Thank you. Committee, any questions? Senator Steinmetz.
Thank you, Madam Chairman. And I still like this bill. We worked it over the interim, but I just became aware of something that I wasn't aware of previously, something called Jane's Revenge. And because I had been hearing questions of why did we need this bill, and then I heard about a list. And do you know anything about that, or could you share anything about that?
Madam Chairman, Senator Steinmetz, I am familiar with the organization. There is a lot of information online. Several years ago when Dobbs was leaked, there were many pregnancy centers that were targeted and had been threatened to be attacked. And I could tell you at the time, this was again several years ago, I personally was a director of a pregnancy center here in the state of Wyoming, and our pregnancy center was on that list, according to our local law enforcement agency. During the House committee hearing on this bill not too long ago, we did hear from another pregnancy center that testified in front of the House committee. That director stated a similar sentiment as well. So
thank you.
Thank you. Further questions? All right.
Chairman.
Yes, Senator Scott.
Madam Chairman, question for the sponsor of the bill. It seems to me like that, since I believe as a matter of principle that the two sides on the abortion issue should not attempt to use the government to impose their point of view on these decisions around abortions and people's ability to express their opinion and act on it, that I ought to be in favor of this bill. Is that a valid argument for being in favor of this bill?
Representative.
Madam Chairman, Senator Scott, thank you for sharing your beliefs. I would just state that it was the will of the committee during the interim of the joint committee to adopt the bill. We heard hours of testimony and also from legal counsel as to the need for the bill. I don't know whether or not you'll hear from legal counsel again, but I would assume you'll hear public testimony that would attest to the need for it.
Thank you. All right, we are going to open this up to public comment. We are again going to give anybody, well, we're going to give 2 minutes. I would like to have a little bit of time to work the bill in the end, so we'll probably take about 15 minutes of public comment. So if you'd like to comment on the bill, please come and fill the chairs.
Madam Chairman, Wendy Volk again from Cheyenne, Wyoming. I'm speaking as a private citizen again. I believe that Wyoming is capable of holding more than one principle at the same time. We can affirm that pregnancy centers serve women with compassion and conviction. Many are faith-based and they should not be forced to violate their mission, perform abortions, or promote services that contradict their beliefs. And we can also affirm that Wyoming Constitution protects an individual's right to make his or her own healthcare decisions. These principles do not cancel each other out. House Bill 3 seeks to protect pregnancy centers from compelled speech or coercion. That is a legitimate concern, but the bill creates an automatic treble damages, mandatory attorney fees, and broad liability provisions. That raises questions about scope, balance, and constitutional exposure. At the same time, we just heard on House Bill 117, we are discussing informed consent in the abortion context. I agree that coercion is wrong, negligence is wrong, informed consent matters. But informed consent standards already exist across medical practice. If we strengthen them, they should be strengthened neutrally, not in a way that singles out one constitutionally protected form of healthcare. Careful drafting protects our conscience rights. Careful drafting of proposed legislation also protects constitutional rights, and careful drafting protects taxpayers from costly litigation. This does not need to be framed as pro-life versus pro-choice. It can be framed as pro-constitution and pro-clarity. Wyoming can respect religious liberty and individual healthcare freedom at the same time. I encourage thoughtful refinement to ensure this legislation reflects Wyoming's tradition of principled, limited, and balanced government. Thank you.
Thank you. Committee, any questions? Okay. Welcome.
Thank you, Madam Chairman, committee members. Again, my name is Britt Borrell. I'm Executive Director for WYO United. First, as I have said in my testimony in front of this committee several times over the last 2 years, including over the interim, I do not protest these centers' rights to exist. I do not protest their right to advocate against abortion. That is their First Amendment right and is protected. No one here is attacking these centers' rights to exist. However, I do not see why this particular group of nonprofits should be afforded special protections under the law. What I do find troubling about these centers is their dishonesty. Their advertisement to women and girls experiencing unexpected pregnancies indicates that they will provide accurate information about all of the options available to them, including abortion. But they peddle misinformation about abortion care, in particular with the explicit intent to dissuade. This is not informed consent. Several of those testifying on behalf of these centers today will likely state that they offer medical services. Then why are they not licensed? Because these centers are completely unregulated, they are under no obligation to have certified ultrasound techs administer those tests. In fact, there is ongoing litigation against a center in Massachusetts that failed to diagnose an ectopic pregnancy with that ultrasound, and the woman ended up losing her fertility. I'm also concerned over these centers' lack of adherence to HIPAA. If they are going to present as healthcare providers and collect sensitive private information about Wyoming women, they should be required to protect these sensitive data. They are not bound by HIPAA, and confidentiality statements on their websites are completely unenforceable. Finally, I have major problems with this bill's provision to protect these centers' rights to push abortion pill reversal procedures. According to the American College of Obstetricians and Gynecologists, this is unproven and unethical care. I sent the members of the committee information on the dangers of this supposed care as well. So please vote no or amend this bill to enforce HIPAA compliance and eliminate protections for pushing untested, unethical treatments. I would stand for questions.
Committee, any questions? Okay, thank you.
Thank you.
Anybody else in the room who'd like to testify on this bill, please come forward. Oh.
Go ahead.
Thank you. My name is Linda Burt, and I'm again representing Wyoming Right to Choose. Just briefly, this bill is not necessary because these rights are protected under the First Amendment of the United States Constitution and under the Wyoming Constitution. And in fact, courts have been very gracious to crisis pregnancy centers, particularly the Supreme Court, in giving them and protecting that right of free speech. The California court was found, the case was denied by the Supreme Court in their free speech issue. There is another case that the Supreme Court just heard regarding a crisis pregnancy center in New Jersey that the court at this time seems posed to find for that crisis pregnancy center. The New York federal court just found in December that crisis pregnancy centers have the right to tell individuals that their abortions could be reversed. Their free speech rights have been adequately protected under the Constitution. There is no need for Wyoming to have a special privilege for these organizations. In addition, our Constitution, Article 3, Section 27, denies the right of organizations to have special protections. You can do a blanket protection for all nonprofit organizations that would follow these rules, but you can't single out one organization under our Constitution to have special protections from the legislature. Just briefly on the intervener issue, the Supreme Court, our Supreme Court in Johnson v. State was very clear when they denied the intervener. It's a constitutional issue in terms of separation of powers. They said that the legislature does have representation. That representation
You're at 2 minutes.
is the AG of Wyoming. Thank you.
Thank you. Welcome.
Thank you, Madam Chair, and members of the committee again for the opportunity to speak in strong support of this bill. My name is Krista Reister. I'm a private citizen from Cheyenne, also pro-life liaison for Wyoming Family Alliance. During the House hearing, nearly every person in opposition acknowledged that pregnancy resource centers do meaningful good in our communities. Only one witness claimed these centers are a threat to public health, citing the American College of Obstetricians and Gynecologists. This is a serious accusation and deserves scrutiny. ACOG is often presented as neutral and authoritative. In reality, it is a professional membership association that has declared abortion to be essential health care. That means it approaches this issue with a policy conclusion already in place. In its own brief on what it calls crisis pregnancy centers, ACOG avoids the word woman and instead uses pregnant people. Pregnancy is a biological reality unique to women, and medicine depends on biological precision. When language shifts away from that clarity, ideology is shaping the discussion. Even the label crisis pregnancy center reflects that framing. Pregnancy is not the crisis. Poverty, fear, coercion, and lack of support often are. These centers exist to address those underlying challenges with practical help, and the impact is measurable. According to the most recent national report from the Charlotte Lozier Institute, nearly 2,800 centers served more than 1 million new clients in the past year and provided over $450 million in free medical services, education, and material support. 8 in 10 offer medical services staffed by licensed professionals. Here in Wyoming, centers provide ultrasounds, parenting classes, diapers, formula, STI testing, post-abortion support, fatherhood programs, help enrolling in WIC and Medicaid, and employment partnerships like Climb Wyoming, all at no cost to the client. That is not a threat to public health. That is community care meeting real needs. ACOG statements are neither neutral nor binding, and this bill reflects our state's commitment to both truth and compassion. I respectfully ask for an aye vote. Thank you, and I will stand for questions.
Any questions? Good. Thank you. Next.
Madam Chairwoman, I'm Dr. David Lynn once again. I come to offer support for this bill. Pregnancy centers were created mainly by Christian groups to offer women who become pregnant with compassionate confidential services, including pregnancy test, STI testing, education classing, counseling, donated baby formula, diapers, and clothing. In these centers, professional healthcare providers, doctors and nurses, provide these services. Communities come together to provide funding and services to assist pregnant women. Churches and other religious organizations provide these services as a ministry to show love and respect to other humans. In these communities, there are definitive benefits, which are provided without draining resources from the government. In order to continue providing care to many vulnerable women, this bill is written to keep governmental overreach from encumbering pregnancy centers. Many states, up to 1/3, have introduced some form of legislation to force pregnancy centers to follow certain rules. Many of these rules are in conflict with their Christian ministry. This bill is an effort to allow pregnancy centers to continue to provide their faith-based ministry unencumbered by governmental regulations. I encourage you to vote yes on this bill, and I'd stand for questions.
Thank you. Any questions for Dr. Lind? Okay, thank you. Next,
Madam
welcome.
Chairman, and esteemed members of the committee, thank you so much for listening today. My name is Alicia Ruiz, and I would like to give insight to the experience of a pregnancy care center patient. I have 2 children, one of which would not be here today without our local pregnancy care center. Almost 6 years ago, I was a client of Life Choice with an unplanned pregnancy. My relationship of 17 years was in ruin due to my infidelity, and the paternity of my child was uncertain. Financial strain was also an issue as we lived paycheck to paycheck, and I did not have good health insurance at the time. Due to these circumstances, I had scheduled an appointment to have an abortion, and I was within days of following through with that. I received sound counsel to have an ultrasound before aborting and was referred to the local pregnancy care center because the services were free. The staff would have normally been in surrounding communities with their mobile medical unit that day that my significant other called, but the executive director happened to be in the building and answered the phone. She contacted the nurse in the mobile medical unit, and they turned around from their course to Torrington and came back to Cheyenne just for my appointment. And I point that out to show the dedication that those working in pregnancy care centers have to serve their community, the marginalized and the underserved. Upon my arrival for my appointment, I was shown great compassion and care. My intake was the same as any other provider I've been to, including clear privacy policies. I was informed of all of my options regarding the pregnancy. I personally was scheduled to do a chemical abortion. And with my consent, they let me know all of the information about what that would entail, the medications, what it would look like, how it works on the child, and how it would affect me as well. After all of the information was given to me, I consented to go ahead with the ultrasound. And once I saw the ultrasound,
2 minutes.
Yes, ma'am. Thank you.
Thank you.
Madam Chair, Madam Chair and members of the committee, my name is Valerie Berry, and I'm here on my own accord. Across this nation, pregnancy centers have received harsh legal scrutiny in 1/3 of the states. What begins elsewhere has a way of seeping in like smoke under a door. Quiet, gradual, and easy to ignore until the air has changed. If we fail to act, we invite it in. We would be naive to think that Wyoming is immune to the national trends and quiet, gradual changes. For example, the Wyoming Supreme Court invoked language that adults have the right to make their own healthcare decisions, but interpret that to include abortion. I respectfully disagree. Abortion is not healthcare. It is the intentional decision to end the healthcare of a developing human, a life that if allowed to follow its natural course would continue to grow in the womb. All of the services provided by pregnancy care centers are at no cost to patients and no cost to taxpayers. Pregnancy care centers provide medical services performed by licensed doctors and registered nurses. We also provide after-abortion support, and offering parenting, education, material assistance, and ongoing support so mothers and fathers are not left to face difficult circumstances alone. Yet in other states, centers like ours are being pressured to post government scripted messages or comply with regulations designed to discourage life-affirming work. That is not the Wyoming way. The CARE Act is a guardrail. It does not regulate other clinics. It does not restrict other providers. It is proactive. You're not giving pregnancy centers new benefits. You're preventing targeted burdens. It simply ensures that if the pressure seen in other states reaches our borders, Wyoming law is already clear. This is where Wyoming says we will not allow outside ideologies to quietly reshape our values. This is where we say the government will not target organizations that provide life-affirming work. The Code of the West says know where to draw the line. This is that line. If we fail to act, we invite it in.
We're at 2 minutes.
May I finish? I respectfully urge the vote to aid on the CARE Act and to stand for life, liberty, and the values of the majority of your constituents across Wyoming. Thank you.
Thank you. Committee, any questions?
I'm gonna, no.
Okay.
Thank you. Yes.
I have one question, because you mentioned that you provide after abortion
Yes.
support. How often, or has it ever come up in conversation that women have said that they really didn't understand the complications of the abortion and that type of thing? Does that happen often in talking with these women?
Yes, absolutely. Not only did they understand maybe all the options available to them, but they were clearly not understanding the emotional, spiritual, and physical effect that it would have on them for a lifetime. Many women regret the abortion that they had, even up to we've counseled and talked with women that have had an abortion 50 years ago and have suffered under the effects of that, recognizing that they took the life of their child. And so surrendering the secret allows them to walk out from under shame and be able to heal from having an abortion. Yeah.
Thank you.
Madam Chair, just to.
Senator Hutchings.
Thank you. Just to kind of stack on your question, Mrs. Ruiz, do you feel the same way that the care you received, you got more information than you knew before? Thank you.
Madam Chairman and Senator Hutchings, thank you. Yes, definitely. When I called to book my appointment for an abortion, there was, obviously they don't do a lot of information over the phone, but there was no information really given about what that would entail. The only thing was I was pressured because I was almost at the 10-week mark. And so they were really pushing to get me in on that Saturday. And I went in for my appointment with the local pregnancy care center on that Monday. And so when I went to the care center, I did learn more about what all of the recourse would look like and the effects that I would suffer personally from the medication itself.
Thank you. Further questions? Thank you.
Thank you.
Any other public testimony in the room? Okay. There's online, okay. And we're gonna do the same committee as we did because we've got to get upstairs here in a few minutes. So if anybody online with public testimony, if they would please email the committee, we would be happy to hear their testimony via email. And public comment will be closed. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Steinmetz, seconded by Senator Hutchings. Senator Scott.
Madam Chairman, question for the committee. I thought that the testimony that this was at risk for a challenge on special legislation on violation of 327 in the Constitution had some force, and that might succeed in courts. How would the committee feel if we were to broaden this bill so that it covered not only the pregnancy centers, but the Planned Parenthood type? And we wouldn't mention it by specific name, but the centers that do counsel the abortions and say they couldn't be interfered with either. and treat the two of them the same in this. I think that would get away from that challenge. But how would the committee feel about that?
Thank you, Madam
Hutchins.
Chair. I think it was noted by the woman who runs the pregnancy center that they're not going to receive any special benefits or privileges like was mentioned. And I kind of looked through Article 3, Section 27, and looking through the bill, I don't see that. And aligning the two, I think we're talking about apples and oranges here, so I would disagree with that, Madam Chair.
Thank you. Senator Steinmetz.
Thank you, Madam Chairman. I think we would also run a risk with amending the title of the bill the way things went yesterday with one of the bills we were working on. I think we would run a huge risk of that.
Yeah.
So I'd be opposed to that.
Thank you.
I don't think I got the votes, Madam Chairman. I do think the bill is at risk over that.
I think you're reading the committee correct, Senator Scott.
And since, Madam Chair, if you don't mind, since we've moved the bill and seconded it, I'd like to withdraw my amendment. You didn't
Sure.
see it, but it's
No.
there. I'm going to withdraw it.
Oh, okay.
Thank
I
you.
heard,
Thank you.
thank you, Senator Steinmetz. Hutchings. Oh, I apologize.
No problem.
That's okay. It's a compliment.
Not enough, not enough.
Madam
Okay.
Chairman, in the
Yeah.
interest of time, I would like to move the amendment that you provided with one small change.
Okay.
On page 5, line 18, we're taking out the word pre-viability separation. And I think we need to leave the word separation in because if we take both out, it doesn't read correctly. So I would defer to you on that amendment because you proposed it, but in the interest of time, I'm moving it to try to get it to work out. So then
Okay.
it would read, perform a separation based on reasonable medical judgment. If we leave pre-viability separation out, the whole thing, it would be perform a based on reasonable medical judgment. And I don't know what we would be performing.
So that's,
So, members of the committee on this, what it was supposed to and should.
So does everybody have the amendment I just moved and staff?
and this is on
We should-
page,
It'd be page
7.
5,
Okay.
the page 5, line 18. It was saying delete pre-viability separation and page 5, line 19, when the procedure. Oh, okay, so it was
It's-
supposed to leave procedure.
Yeah, we
Oh,
leave
gotcha.
procedure in.
All right, thank you for catching that. So then
Okay.
that does work. All right.
Yeah,
Okay.
okay, yeah, because I just think we still want that word procedure, so it should just say perform a procedure
Got you. Thank you for catching that.
based on reasonable medical judgment necessary to save the life of or prevent serious physical injury to the pregnant
Gotcha.
woman.
Thank you.
No, thank you for that because I actually questioned our doctor on that. Same
Okay.
thing, so.
Very good.
So this amendment would strike the pre-viability procedure and then when the procedure is, and then it would just take out the definition of pre-viability procedure on page 7, which is lines 6 through 16. This, I had this amendment drafted up because I think it just leaves the bill clearer on what we are doing as the pre-viability separation procedure definition was, I had a hard time understanding what it was doing and I've worked and studied in this area before, so I would second that motion and any discussion on the amendment? All right, seeing none, all those in favor of Senator Steinmetz's motion that we propose this amendment, please say aye.
Aye.
All opposed, no. All right, that amendment is adopted. Any further discussion on the bill?
Madam Chairman,
Senator Scott?
I'm going to vote for this bill here in committee. I do have serious reservations about it as being unbalanced and possibly special legislation. I'm going to think about that for the vote.
Thank you, Senator Scott. Any further discussion on the bill? Senator Steinmetz?
Thank you, Madam Chairman. I'm going to vote for it. I didn't vote for the rodeo museum bill for just that reason. But I believe there's more than one pregnancy center, unlike the museum where there was one. And so I will be voting aye on this bill.
Thank you. Further, hear the question being called. Will you please call the roll?
This is a roll call vote for House Bill 3 as amended. Senator Crum,
Has left an absentee vote of aye.
Senator Hutchings,
Aye.
Senator Scott.
Aye.
That was an aye.
Aye.
Senator Steinmetz,
Aye.
Chairman Brennan.
Aye.
Madam Chairman, that is 5 ayes.
All right, thank you. With that committee, we will adjourn and be back for more on Friday.
Debbie, if you want this bill, I